In my experience, students find this unit frustrating. There's a great deal to memorize, and they often find themselves asking, what's the point? Who cares that much? In some ways, it's a funny question for people who live in Utah. Utah was born in a federalism dispute. I mean, it's the only state in the Union whose admission to the Union was predicated on passage of a particular kind of marriage law. That is a law governing polygamy. And we're now returning to debates over marriage laws. But, for most of our history, that has been relatively uncontroversial, except in Utah. People outside of the United States, and I'll get to this in a moment, look at our federalist system with some bafflement. They see duplicated resources, costs, parochialism on the part of states. So let's start out by thinking about arguments in favor of federalism, because certainly the founders had an uphill battle convincing their fellow Americans, their fellow citizens, that a system that was less federalist than the Articles of Confederation was a good idea. They certainly would have said, and in many ways it remains true, that state governments are closer to the people. For those of you who find Utah's government irritating, keep in mind that many of its laws, in fact, do reflect the democratic preferences of a group of citizens who may not be typical of the country, but who have, because they live in this state, a political voice for their opinions. Not, of course, without basic civil liberties protections, or at least most of the time. States are also a laboratory for new ideas and policies. Back when I was studying political science, with my pet stegosaurus along, states were mostly considered to be themselves dinosaurs, but that's a very ahistorical view. Almost all of what we would consider major social innovations, from pension plans, labor policy, public education, were initially state initiatives that were eventually picked up nationwide, and that's still happening. I think some of the more interesting experiments with educational reform and with healthcare delivery are really happening at the state level. It promotes diversity among political cultures. Yeah, maybe you like, maybe you don't like Utah's political culture, but is it really a bad thing that Utah has a different political culture than my home state of California, and certainly my home area now, the Bay Area, or New England, or the upper Midwest? I mean, people in this country do, in fact, have some choice about where they live. And diversity means that it's possible to find a place where one is more comfortable. And so San Francisco, for example, fairly early in the gay liberation movement, I'm not even sure it's called that anymore, I'm showing my age again, became a political as well as a social safe haven for people whose sexual preferences at that time were considered unacceptable in a lot of jurisdictions. And in many ways, San Francisco not falling into the sea when it changed its policies helped persuade other people to move in that direction. And finally, the same thing that people complain about, which is that huge amounts of resources are duplicated by having, national and state government and then city government. Another way of looking at it is that citizens have a whole bunch of different levels of government that they can participate in. Americans vote more than other people, and they vote for more offices. Again, overseas, a lot of people think America is just one nonstop election and think it's crazy, but it's also true that by all the various measurements of involvement, participation, sense of efficacy, sense that their political views matter, Americans rank quite high. And one reason is that they can have an influence at the state and local level. So the big counter-arguments, well, you've read James Madison's already. Factions can more easily block progress, promote majority tyranny in a state. So Massachusetts, for example, maintained an established religion into the 1830s, even though the First Amendment outlawed a national established religion at the end of the 18th century. I won't even go back to Utah, but there are all sorts of ways in which a state can impose majority rule that it couldn't impose nationwide. Political scientists talk about the tragedy of the commons. What this involves is a recognition back when there were common pastures that they tended to be overused because every individual person putting their cows on the pasture had an incentive to have that cow eat more grass, even if the collective was worse off because the grass was being destroyed. And if you doubt this problem, just check around in southern Utah and look at the results of overgrazing. Federalism promotes this to some extent because states have an incentive to seize resources at the expense of their neighbors. The classic example of this is really the first settlers in this part of the world were the Mormon settlers in Utah, and they were amazing engineers. Some of the canals and water delivery systems that they basically built with pickaxes were amazing. But one of the things they did was divert water from the entire Colorado basin into Utah. Utah has a water problem, but frankly, it's less severe than a lot of its neighbors, and part of that is because we got there first. Another argument is that uniformity promotes justice. Why should, for example, a gay spouse's access to benefits depend on his or her state? A very confusing state of affairs after the recent Supreme Court decision. So which way does it go? I like the fact that the AP textbook has some quotes, and I'm just putting them up there so that you stop and think about it. Parasitic and poisonous, the idea that on the one hand, states suck up resources. Poisonous is the idea that they're places where prejudices and parochialism abound. It is certainly true that states maintained policies of racial segregation, Jim Crow laws, etc. in the South long after they were no longer, well, to say they weren't tolerated in the North is a little too kind to the North, but at least they weren't written onto the books. This long quote from Daniel Eleazar is actually kind of hard to read, but the idea that federalism creates strength because you have government at different levels, to some extent competing with each other for loyalty and with ideas, political flexibility. If one branch of government can't get something done, then another branch of government may be able to tackle it. And individual liberty, the notion that the existence of different states with different policies does, in fact, create some individual choice within the national system. Again, of course, it's a choice that involves packing up and moving to where you feel more comfortable. But people do this all the time. They gravitate toward the coasts if their social or political views are more liberal, toward the Sun Belt or Texas if they aren't. I'm not saying everyone moves to those places for those reasons, but that is a kind of liberty that is maintained in American politics that many countries don't have. Okay, just brace yourself. There's a whole lot of constitutional information in this unit, and some of these things you just have to memorize and understand terminology, but if you can get past all the vocabulary words and IDs, if you will, there's some really important concepts that over your lifetime will help you better understand what's going on in all the crazy things happening in the news. Enumerated powers, enumerate, it's like numero, it really means name rather than number. It's powers that are specifically given to Congress. This is Article 1, Section 10 of the Constitution, coining money, declaring war, etc. Concurrent or shared powers are powers that both branches of governments have. So we have state and national taxes. State governments can also borrow money, but they can't print money. That's a very important power that's reserved to the federal government. Both levels establish courts. Now, I'm not talking about some other categories, implied powers that may or may not be, that they're implied in the Constitution, not specifically stated. Reserved powers means powers that the states keep, that they're not given over to the national government. But these are the concurrent and enumerated are the biggies. So some other elements of the Constitution that have an impact on federalism. Now, the necessary and proper clause, the elastic clause, you've met in the first unit, and you'll talk about again when you look at the judiciary in the next unit. But basically, this was the we can't predict everything, so we're going to leave ourselves an escape clause. And there was a great deal of debate about just how far this went, and we'll talk about that in a minute. The 10th Amendment says that powers not delegated to the United States nor prohibited by it to the states are reserved to the states or to the people. This was put in at the insistence of the Anti-Federalists. Historically, it hasn't meant much, although periodically the 10th Amendment is evoked. Let me just note that for some reason, at least in the days when I was teaching AP government, the 10th Amendment shows up a lot on the AP test, so know it. The Supremacy Clause says that, and it doesn't use the word trumps, but I think it's actually a good one if you play cards. National law trumps state law if the two conflict and the national law is within Congress's power. So an interesting example of where the Supremacy Clause does not apply is alcohol laws, because the 21st Amendment in ending prohibition specifically grants states the right to regulate alcohol. You're wondering how you ended up with a uniform 21-year-old drinking age? We'll get to that. So, for example, the Supremacy Clause was invoked by the Supreme Court when it overrode California's medical marijuana laws. Basically, the state police power enables them to regulate drugs, but the national government has a drug policy too, and the national government wins. This, by the way, was very disputed by federalism advocates, people who think that state power is easily eroded, even people who basically didn't like medical marijuana laws. This example actually highlights another thing about federalism and the Supremacy Clause, which is, in some ways, what really matters in this case is whether the federal government bothers to enforce its opposition to medical marijuana laws. At the time that the Supreme Court made this decision, the feds were making a pretty big effort. As you may have noticed, they're pretty much letting these medical marijuana laws stand and be enforced at the state level. Interstate rules of the road. Oh, this is the sort of picky stuff that, if they have indigestion over Labor Day weekend when they write the AP test, the AP test writers may throw at you and often do. The full faith and credit clause basically says that other states have to honor legal agreements made in another state. This comes up with contract law. There are all sorts of ways in which the full faith and credit clause is important. Where it's been most controversial has been marriage. Now, I would note that, in fact, there are exceptions to all of these rules, and there have been exceptions to marriage rules for quite some time. So there are states, for example, which allow couples to marry, particularly women, to marry as young as 14, and there are states that refuse to recognize those marriages. So the fight over whether or not gay marriage is recognized is not actually unique, but it has introduced a whole new element and made much more complicated by the Supreme Court decision, which really, on the one hand, said that the Defense of Marriage Act cannot impose a rule on the states, in that way upholding federalism, but also didn't come right out and say that different state marriage laws are unconstitutional, and that the Equal Protection Clause of the 14th Amendment means that states have no business penalizing people in one particular form of marriage. My personal guess about this is that we're going to see a lot more litigation, a lot more cases in the Supreme Court about this. I mean, not my personal view. I think everyone thinks that. Privileges and immunities say that if you're a state, you have to extend the same rules to citizens of other states. So, for example, I drive around in Utah about 4 months of the year when I'm living here with my California license plates, much as they would like to, and I sometimes think they would. The constabulary down in southern Utah, where I have my cabin, cannot, in fact, impose a higher speed limit. I mean, now they can, and in my experience often will, decide that they would much rather give a ticket to somebody with a California plate than a pickup truck that looks like it's one of their neighbors in Wayne County. Nevertheless, you can't have a California speed limit and a Utah speed limit. Now, an interesting exception to this is in-state tuition, and that has been upheld. If states are going to grant each other's citizens in-state tuition, they do it through some sort of a legal compact. In-state tuition has been ruled to be an acceptable exception because it's related to the level of state taxation. But again, I'm just pointing out that none of these rules is absolute. Extradition simply means that you have to send criminals back home. Now, this has not been as big an issue on the national level. Some death penalty advocates think that states should fight extradition of criminals to other states that impose the death penalty. They haven't gotten real far with that. On the international scene, however, this is a huge issue. And there are, the recent debate about whether Edward Snowden would be returned to the United States hinged in part on the opposition on the part of some countries to the United States death penalty, and there is, by the way, a federal death penalty as well as a death penalty in some states. We will talk more about the death penalty in the next unit. Okay, some big cases now. You encountered these in U.S. history, especially if you took AP U.S. history. In my experience, you've forgotten a lot of them. This was early in the course. Here's your reminder. McCulloch versus Maryland was that big case testing whether or not Congress could, in fact, create a national bank. And there were two parts to the ruling, both of which were very important. This case, by the way, shows up all the time on the AP test. You needed to know it for AP US history. You need to know it again. So first, it upheld, or to put it in a better way, it upheld a broad reading of the elastic clause, of the necessary and proper clause. Congress can establish a national bank even if the Constitution doesn't say so directly, because Congress is given power to print money and conduct other kinds of financial affairs, and they can decide the best way to do that is through a bank. And states cannot tax a federal bank. The famous quote from this is, "The power to tax is the power to destroy." This case was extremely important in establishing the power of the national government vis-a-vis the states, and Thomas Jefferson hated it with a passion. Gibbons versus Ogden, and these two can get confused. The two words you need to keep in mind for this are Commerce Clause. Basically, this was over whether New York could grant a monopoly to rights over traffic on the Hudson River. As you might expect, the person trying to operate from New Jersey objected to this. This was a big political struggle, but the Supreme Court ruled no, New York could not do this because it violated Congress's power to regulate interstate commerce. That is just the beginning of a long story. Basically, the Marshall Court, the first powerful U.S. Supreme Court, early in the country's history, defined commerce broadly as anything that affects economic activity in more than one state. What we're going to see is how commerce is defined remains a hot legal and political issue and has fluctuated back and forth throughout U.S. history. I'm going to give you just a little bit of that history. The Civil War was all about the national government gaining power over the states. I'm sure you all realize that. But the 14th Amendment was specifically enacted, to fight black codes. That is, state laws that were restricting things like the ability of African Americans to be out after dark or to own weapons, etc. The 14th Amendment guaranteed due process and equal protection to citizens of states, and in other words, was a limitation on state law. Powerful as the 14th Amendment has proved to be, it took a fair amount of time, at least after Reconstruction had pretty much ended in 1877. It took a long time for this to be, for the 14th Amendment to be applied as strongly as, in fact, the Reconstruction era Congress that passed it probably intended it to be. The states, of course, had to adopt the 14th Amendment in order to be admitted back into the Union. You probably remember Plessy v. Ferguson. That was the case that said separate but equal is okay, and it basically determined that states would be able to practice legal racial segregation for another several decades. We'll talk about this case more. You'll talk about this case more when you get to the civil rights discussions in the next unit. But in some ways more important for the story in this unit is there were a series of cases that limited the Commerce Clause. So, for example, the Supreme Court ruled that manufacture was not commerce. And so there were all sorts of laws regulating factories, hours of work, things, child labor, things like that the Supreme Court struck down on the argument that this was not interstate commerce. Now, they didn't strike everything down. You sometimes hear simplistic discussions of this, but for our purposes, this is a period when the Supreme Court is interpreting the Commerce Clause in a quite limited way. Well, what really hit the fan when the Congress passed, at the Franklin Roosevelt administration's request, all sorts of regulatory laws. And the Supreme Court struck down a series of them. Then President Roosevelt proposed packing the court. Remember that one? And in what was referred at the time, somewhat humorously, as a switch in time saves 9, the Supreme Court began basically one vote switched and New Deal legislation started being upheld. And from there, frankly, all the way into the 1990s, almost everything is viewed as commerce. You may wonder what Ollies BBQ is. I will tell you, Ollies BBQ was a barbecue shack in Alabama. I think, though I'm not certain, it was Montgomery, Alabama. It was not a chain, not, in fact, a very big place at all. And Ollies BBQ argued that it did not have to obey the Civil Rights Act, saying that you have to be open to all comers as a public accommodation because it was not involved in interstate commerce. Hey, we're just a very little local business. We don't have branches in other states. Forget it. Well, the Supreme Court said, you forget it. You are engaged in interstate commerce. Truckers come off the road and stop at Ollies BBQ. Some of your pigs come from outside of Alabama. There are ingredients in that barbecue sauce that were not made in Alabama. And it became a very famous case. Now, we move to a point in the 1990s where federalism makes something of a comeback. The big case, well, there are three big questions, but this one is by far the most important, which is how broadly can interstate commerce, I shouldn't really say commerce, interstate commerce be defined? The Lopez case, which struck down the Gun-Free Schools Act, and the Morrison case, which struck down the Violence Against Women Act, Lopez is the more famous of the two. The Supreme Court said there is a limit to what can be considered commerce. And by the way, the Supreme Court was not arguing that people should be toting guns in school or beating up women. The Violence Against Women Act, though, required, for example, stronger penalties when it was a crime against a woman. Basically, what the Supreme Court said is these are state police powers. This is not interstate commerce. The Commerce Clause may be elastic, but at some point it snaps. Here's where it snaps. Now, that was the most famous Commerce Clause back when I was teaching this course, but there is a more famous one in many ways now, which was the Supreme Court ruling on Obamacare, which is more complicated than you may have realized. The administration argued in court, the Solicitor General of the United States under the Obama administration, that the Commerce Clause justified the requirement that all individuals pay health insurance. And the Supreme Court, you probably know that the Supreme Court upheld Obamacare. What you may not realize is, in fact, the Supreme Court struck this down. It said, no, this is not commerce. It doesn't count. It's like Lopez. But it's a tax. Now, the administration had, I think more for political than legal reasons, argued that the individual mandate was not a tax. The Supreme Court said, sure it is. Looks like a tax, quacks like a tax, etc. And you can tax. So it's all right. And then there's the fact that although you have cases like Lopez and Morrison, you have other cases that say that there are limits to federalism. And by the way, these cases are not necessarily consistent. Sometimes it reflects a change in justices. So I've already mentioned medical marijuana. The courts did not uphold California's right to regulate its own, medical marijuana grown for at least allegedly medical uses. South Dakota versus Dole was a very famous case, and a lot of people, actually including my husband, who teaches constitutional law at Stanford, think was wrongly decided. Basically, the United States passed a law under a lot of pressure from Mothers Against Drunk Driving, an organization, by the way, that I admire. What it said is that 5% of your federal highway funds will be eliminated if you do not raise your drinking age from 18 to 21. South Dakota objected to this. The legislature didn't like being told what to do. Most legislatures just up and did it, partly because there was a lot of evidence that a higher drinking age did cut down on vehicle alcohol deaths. There are arguments that it's increased, for instance, binge drinking in colleges. We're not going to go there now. But that was the decision. South Dakota objected, and the Supreme Court said yes. Basically, the Congress did not say that you have to raise your drinking age. They just say you're going to lose some serious highway money, which you'd love to get, particularly if you're South Dakota, which has more road miles than people, and that was upheld. Okay, these get pickier. I'm going to go fast. Can federal mandates go too far? Yes. The Prince case said it was too much to require state employees to check the backgrounds of handgun purchasers. Again, not really an anti-gun control decision so much as saying this is imposing a big requirement on states. You're not giving them money for it. The federal government can't tell states how their state police officers are going to spend their time, essentially. But another big one was, again, the Medicaid quote-unquote mandate in Obamacare. And what really, and I'm using it as a shorthand, of course, it's the Affordable Health Care Act. And please understand, I'm not attempting to be disrespectful. I think everyone calls it that now. But basically, the law requires states to very much expand Medicaid provision and then offers basically, I forget the exact amount, but something like 95% of the money to do it, at least for the first few years. But they have to do it. In other words, you're required to expand Medicaid, which is a combined state government program where usually the states have set the rules for eligibility, et cetera. The Supreme Court said no. I mean, the federal government has a right to withhold that extra money, but they can't withhold all Medicaid money because states refuse to accept this expansion. And now there's a huge political debate going on in states about whether they should, in fact, expand Medicaid, and you've got some articles about that. This is pretty picky, and I'm not sure I should have left this in. But the 11th Amendment, which is a pretty obscure one, says that states cannot be sued for violation of rights established by federal laws unless the state agrees to be sued. So Florida cannot be sued for violating the Age Discrimination Act. By Florida, I mean state government officials. A private business in Florida can be sued. We're talking about suing state governments. Interestingly enough, states often do agree to be sued. They enter into an agreements with advocacy groups, et cetera, and say, yeah, we need to resolve this legally. But I mean, it's kind of a minor point, but since we're talking about federalism, I'm going to throw it in. Your book talks about this, and the AP examiners very often ask about it. And in some ways, the distinction is a little too simplistic. But you'll hear about two models of federalism. Dual federalism is the idea that there is a state sphere and a national sphere, and they don't really coincide. This is called layer cake federalism for an obvious reason. And to a large extent, this was the theory that animated the Supreme Court between the 1870s and the New Deal. Cooperative federalism or marble cake federalism is the idea that state and national government efforts are inextricably combined. And cooperative federalism is probably here for good. And the reason, quite simply, is the huge amount of federal money that is now available for state programs, much more than you probably realize. Most big government programs, and Medicaid is an excellent example, operate with federal money or combined federal state money, but state administration. And that is cooperative federalism. And essentially it solved what was perceived as a constitutional problem, that the federal government was spending money on things that fell within what's called the police power of the state, a term I think that we encountered in the last unit, at any rate, one you should know and is defined in your book. Categorical versus block grants. This is another fight that keeps going. And your book has a very good description of why block grants have not become more popular. And then some of the answer to that is they tend to be more popular with Republican administrations than with Democratic administrations. But categorical grants basically require that a locality or a state, often a locality, has to do something specific to get federal money. Example, minority hiring is actually a little unclear. Often to get federal money, you have to meet certain criteria, such as hiring a certain number or a certain percentage of minorities. But a good example of this would be grants that are given to the states in something called Race to the Top, where states were competing for $4 billion in education funding by presenting proposals to the Department of Education about changes that they were going to make to improve education. A lot of these had to do with greater accountability for teachers, permitting charter funds. Interestingly enough, a Democratic administration kind of enforcing what might have traditionally been a more Republican set of policy objectives. Block grants are more open-ended. You give the states a chunk of money and they say, well, we'll let you figure out how to do it. And the most famous example of moving something from a categorical grant to a block grant is welfare reform in the 1990s. Essentially, aid for families with dependent children, the traditional welfare program, gave out federal money pretty much automatically. States had some power to determine eligibility, particularly income levels. As the welfare rolls expanded and there was more and more concern that generations were being trapped in welfare, an interesting coalition of a Republican Congress and President Clinton passed new law, TANF, the Temporary Assistance to Needy Families legislation, which essentially gave welfare money to states and let them experiment with approaches like work requirements, et cetera. It was considered wildly successful by many people because the welfare rolls declined. But, since 2008 and the, much more difficult economy, welfare rolls have been growing. And that's partly because the Obama administration has in fact issued regulations loosening up some of these requirements. And this is another area where the federalism fight is alive and well because many states objected to those regulations. And there are questions about whether the president had that authority. Federal mandates are when the national government orders state governments to take some action. So, for example, I mentioned the tragedy of commons and the fact that, why shouldn't Colorado dump its waste into the Colorado River? Who cares what floats downriver? And the answer is the national government cares about that, as do the states downriver. And so the Clean Air and Clean Water Act, same thing goes for emitting junk in smokestacks that are going to blow someplace else. That's a classic example where the national government has not given the states all that much money, but has required them to impose more nationwide standards. Nationwide's a little complicated because they're often regional, and you're going to be looking at some of these laws. But that's a good example of an unfunded mandate. The Medicaid debate is a debate over a funded mandate. What opponents of accepting that money say is, look, we could enact all of these changes, expand Medicaid, and then Congress next year could decide they don't have enough money, and they're certainly short of money. And so they're going to cut back the amount that they give us. Many people feel, I will perhaps inappropriately tell you that I think there's a lot to this argument. The Medicaid is a very badly run program, and that this is an area where some state experimentation with delivery. An example I would give is in San Francisco. There have been experiments, very successful experiments with community health clinics that are much less expensive than most Medicaid providers. And a lot of people feel offer a better level of service, but sometimes you have to get through a lot of Medicaid red tape to allow use of that kind of clinic. Others would say that it's a plot by Republican governors to cut off health care for poor people. Both sides of that debate have strong arguments. Well, are you exhausted yet? Federalism.